Next, we're moving into the final panel of the day, criminal sentencing, mass incarceration, and sentencing alternatives. In this panel, our guests will explore how Ohio courts are implementing science and best practices to reduce over-incarceration and provide access to justice to all who enter our legal system, while still keeping our communities safe. I'd like to welcome our moderator for the second panel, Judge Laurel Beatty Blunt. Judge Laurel Beatty Blunt was elected in 2018 as judge of the 10th District Court of Appeals in Columbus, the first Black woman to serve on that court. Prior to joining the 10th District, Judge Beatty Blunt served for nearly 10 years as a judge on the Franklin County Court of Common Pleas General Division. Passionate about civic education, Judge Beatty Blunt has used her judicial experience to educate the public about the justice system and the importance of voting. Judge Beatty Blunt, take it away.
Thank you, Judge Hejmanowski. And thank you all for our panelists today for being here. First, I would like to introduce Justice Michael P. Donnelly. Justice Donnelly is the 160th Justice of the Supreme Court of Ohio. He took office in January of 2019, following his statewide election in November 2018 to a full term on the court. Prior to joining the Supreme Court, Justice Donnelly served as a judge in the Cuyahoga County Court of Common Pleas General Division for 14 years. And then, before serving as a member of the judiciary, he served as a county prosecutor and as a civil litigator. Thank you, Justice Donnelly, for being here. And next, we have Judge Nicole Sanders, who was elected in 2020 as a judge of the Hamilton County Drug Recovery and Treatment Court, the first drug court in Ohio and the only full-time drug court in Ohio. Judge Sanders, working together with treatment providers, probation professionals, prosecutors, and defense attorneys, oversees innovative, evidence-based treatment consistent with best practices for those defendants whose substance abuse use results in criminal penalties. Thank you, Judge Sanders, for being here. Next, we have Columbus City Attorney Zach Klein. He previously served as a member of Columbus City Council, including 2 years as council president. As city attorney, Mr. Klein is focused on how the law can be applied to promote public safety, encourage economic progress for all, and defend the civil rights of all Columbus residents, and protect the most vulnerable among us. Thank you, City Attorney Klein. And last but certainly not least, we have Professor Douglas A. Berman, who is the Newton D. Baker and Hostetler Chair in Law and Executive Director of the Drug Enforcement and Policy Center, which is housed in the Moritz College of Law at The Ohio State University. Professor Berman's principal teaching and research focus is in the area of criminal law and criminal sentencing. Professor Berman is a member of the Council on Criminal Justice and frequently is consulted by national and state policymakers, sentencing commissioners, and public policy groups concerning sentencing law and policy reforms. So thank you all for being here. So our charge is to talk about criminal sentencing and mass incarceration and sentencing alternatives. And so I wanted to start at the beginning of the process, if you will. And so City Attorney Klein, I understand that you have created a diversion program for people who have been charged with shoplifting, but that program includes really looking at the whole person and including how they got there in the first place. Can you address that?
Sure, Judge, and certainly thanks to the Bar Foundation and my wonderful colleagues on stage here to talk about this really important subject. When I ran for Columbus City Attorney in 2017, and I'm now in my sixth year, I ran on a platform of how we can pragmatically and realistically change the criminal justice system to fix the inequities that have been there for generations, and at the same time continue to promote public safety. And in doing that, we have launched a whole series of real-world changes that I think have improved the system, have helped people of the city of Columbus. And one of them is this diversion program that you're referencing. It's called Buckeye Diversion. And it starts with a very simple question. And the question is, why? Why did this person steal? Now, in the real world, that yields a lot of really complex answers because people steal ranging from food insecurity, drug addiction, mental health, all the way up to they could be part of a global theft ring and they steal, and it's everything in between. So we partnered with a third-party healthcare organization that does a 36-question screen of each individual defendant that's eligible for this big box shoplifting program. So you're stealing from the Krogers, the Home Depots, the Lowe's of the world. And if you are eligible, which is basically everyone from 0 offenses all the way up to about 8 or 9 offenses. So it's a wide range of recidivism history that we allow people into this program. They do a screen that asks questions about drug addiction, about mental health. But what makes our program unique is that it also asks questions about food insecurity and housing, transportation, logistics. And each individual defendant gets a tailored plan that's special to him or her based on what they identified as the reason they steal. And we've had tremendous success. So we put the case on an inactive docket. And because of the rules we have in court and with speedy trial and statute of limitations to bring charges, there's about a 6-month-ish program that we can run here. But we've had about, I'd say, just over 90% success rate where people do not recidivate because we're addressing those underlying needs of why people commit crime, which from a criminal justice standpoint and then from a prosecutor standpoint, if I can get someone who's made a mistake to not commit crime again, that's a win for public safety. And we have now had the data that show in the 3 years we've been doing it, and one of them was kind of a time off year because of COVID and a lot of pauses that happened. But we have real world data that shows like asking that question, identifying what the specific reason is people are stealing, and then saying, oh, you stole food because you're hungry? Did you know there's a food pantry around the corner from where you live? I had no idea. Well, part of your diversion program is to visit that food pantry. And so we address and identify all those things, and we've had a wonderful amount of success in the program, and now expanding it to other nonviolent crimes as well.
You know, that's interesting because I think when a lot of people think about sentencing and sentencing alternatives, they do not think about the role that a prosecutor can play. And it sounds like part of your program's success is because you're figuring out why. And you're doing that. You know, I understand the title is the city attorney, but it's essentially a prosecutor's office.
With the exception of the police, we are the gatekeepers to the criminal justice system, which is one of the reasons, and again, the reforms that we made as a city attorney is we brought, for nonviolent crimes, charging decisions in-house. We took it away from police, brought it into my shop so that we can work on making sure people are charged correctly based on the facts of the case. They're not overcharged, they're not undercharged, but charged appropriately. And then it gives us the ability to identify Buckeye diversion opportunities. And then the next step is, are there even pre-charged diversion opportunities that we can have? Do we even need to charge someone for a crime, for a low-level misdemeanor offense, if we can treat them through a pre-charged diversion program? Because the charge itself can be disqualifying for economic opportunities or rental opportunities. And if we want people to be the best versions of themselves, to be able to be the moms and dads that they want to be, then we have to be able to give them the opportunity to succeed. And having the charging decisions in-house gives us a lot more flexibility to determine how we can change that person's lives for the better.
Awesome. Thank you. Justice Donnelly, I wanted to ask you a question from before you were a justice, when you were just a judge. And I remember you talking quite a bit about how when you were on the Common Pleas General Division bench, you did not do any plea bargaining or anything in your office. Everything was done in the courtroom, on the bench for everyone to see. Could you talk about why you did that and how you came to have that philosophy?
Sure, Judge. And let me say it's an honor to be here with my distinguished co-panelists, and I think this program is very important. Great question. I came from a court of 34 judges, and I did things a little differently. When I became a judge, I viewed the process through which 97% of all criminal cases are resolved, not through going to trial, but through negotiated plea bargains. I began to look at the process a little differently than I did as an advocate. And I noticed that we would have these discussions that I did not question when I was a prosecutor back in judges' chambers. And the prosecutor would be presenting the specifics of the plea bargain. The defense was often looking for a very important question from the defense perspective. What's going to happen to my client? And we'd have these discussions, and it occurred to me that we were having very important discussions about something that would profoundly affect the defendant's life if they chose to enter the plea bargain. And if there was a victim in the case, they weren't present there. And in what I've described in some of my writings as the greatest epiphany of my career, I basically came to the conclusion that no one should ever say anything in the back chambers that they wouldn't repeat on the record. So one day I told my bailiff, John, we're going to do some things a little differently. We can have these same discussions that we had, but we're going to do everything on the record. And I never looked back for the rest of my term for about 10 years. And I believe that every judge should be engaging. If they're going to involve themselves in the plea negotiation process, as many common pleas court judges in Ohio do, then it should be on the record. In the federal system, judges are prohibited from being involved. But in Ohio, it's a lot different. Judges to various degrees engage themselves in the process.
And so how do you think that impacted sentencing in your court? I would imagine, for example, there was not an instance where a lawyer said something in your office and then came back and told their client something different, because all the conversation was out in front of everyone. So no one was surprised, right?
Right. No one ever wants to misrepresent or lie on the record, because there's consequences for that. No one wants to appear vindictive. And people generally focus on the facts of the case. And, like I said, everybody is hearing it. If representations are being made to me and I'm going to make a representation about what the consequences are going to be, then I say that on the record, and then I'm held accountable as a judge. If 30 days down the road, I'm in a bad mood or I forget what I said, it's all on the record. And to this day, I've engaged with friendly arguments with my former colleagues back on the trial court about this, and I haven't been convinced that there's any other way that a judge who chooses to involve themselves in the plea bargaining process. One of the flaws that I've described in some of my writings that exist that I think leads to so much disparity in outcomes is that judges don't have any objective criteria that guides them in their discretion to accept plea bargains or reject plea bargains. So you have 400 or nearly 400 common pleas judges in the state of Ohio, and they all have developed different philosophies on how they exercise that discretion. Some judges accept agreed sentences, some do not. This is a major contributor combined with the lack of data in our system that leads directly to disparity, racial and other forms of disparity.
Another topic that gets missed in the incarceration discussion is that of bond. And so reaching further back into your career to when you were a prosecutor, and I'd be interested in any of you answering this question because it is a hot topic of the day. You see in the newspaper, oh, this person wasn't afforded a bond, or this person's bond was too low, or you should consider safety, or you shouldn't consider safety. And I remember also as a trial court judge having those people that were ultimately found not guilty, but because they couldn't make the bond, they'd sat in jail. For one guy that I presided over his trial, he sat in jail for 2 years before he was found not guilty of a rape charge. So what are you all's thoughts on bond as far as it is keeping people in jail?
Yeah, well, there's no question that's what's occurring. I used to call it the culture of plea and release. And what you'll have is someone charged with a bond, and bond is being set not with an examination about the underlying facts, but really based on the nature of the charge. If it's a serious charge, then it's going to get a higher bond. And without really a close examination. And judges aren't, in my opinion, having bond review hearings to determine if that bond is appropriate. As a result, if the bond is excessive and someone sits 4 weeks in jail, and then by the time the adversaries realize, hey, this is overcharged, then oftentimes you'd see it reduced. The defendant, you can imagine the discussion that takes place with their lawyer. Hey, great news. I just had a felony of the first degree. It's marked now to a misdemeanor. What if the defendant says, well, I'm innocent. I'd like to go to trial. Well, you can do that, but we're going to have to set that trial about a month, and I can't assure you that it'll go forward. Or you can walk out in that courtroom and you can take the plea and you get out today. So what do you think is going to happen? And I saw that dynamic every single day in my courtroom.
Mm-hmm. Especially when you start considering, the defendant, while they might think that they're not guilty, they're also thinking about whether they're going to lose their housing, whether they're going to lose their job, whether, their kids might get kicked out of daycare, and lots of other considerations that I think lead to people saying, okay, I'll plead guilty, even though they might have issue with that or with what they were charged with. So Judge Sanders, question for you. We're going to turn to drug court. First, can you tell everyone what a drug court is? A lot of people don't even know.
So first, thank you for the question, Judge Beatty, my distinguished panelists. Good morning. And so a drug court is a specialty court, which it is a therapeutically oriented program that is supervised by probation officers and the judge. And basically what it means is that we try to look to rehabilitation as opposed to locking someone up or being punitive. Drug courts are very successful. Generally, there's an 8 to 26% reduced in recidivism rates. If it's well administered, it's about 35%. Generally, I can give you some specifics locally. Thinking to Lucas County, they did a 3-year study, 18% the first year, 10% the second year, 0% the third year.
Wow.
So they're vastly, vastly successful. And that's because they use both models. They ask the question why. They do individual assessments. They develop case plans for the individual, and then they implement the plan. And then they think about what's justice for this person. Is it the monitoring? Is it trying to solve the underlying reason? Or is it just sending someone to jail?
There are some people who love specialty dockets, and there are others who are very much against them, actually. I remember some judges arguing, why should we have specialty dockets? Because I was elected to serve all the people. And so I can handle a drug case just like any other judge. So why do you think we need drug courts?
So I have the distinction of being the only full-time judge in the state of Ohio. And what I can tell you is that I have resources, training, and time that my colleagues do not. My colleagues have to deal with serious cases from rapes, kidnappings, burglaries, gun violence. I deal with those individuals who commit criminal offenses because of an addiction. So in my room, I have the prosecutor, I have the public defender, I have the probation officer, I have my treatment providers there, and I have an assessment team, and I have peer support. So I have in real time a group of individuals who can assess, make recommendations for treatment, and implement that treatment. So that's why I can handle it as the specialty court judge, and that's why you should have that. You should have a specialty court and I think in every county, because we have the time and resources that general division judges just do not have, nor do they have the training.
And I think that another thing that we have to consider, particularly with drug offenses, is that it's not only the drug offense, but it's the things that addiction makes people do.
So, right, let's talk about the collateral
it's
collateral
the property
consequences.
thefts and, things like that. And so if we went from a fiscal point of view, why do we need drug courts?
So we spend a lot of money on deprived liberty, right? It's about $38,000 annually to lock someone up in prison. we can spend about 1/3 or less than 1/3 of that amount to rehabilitate someone. You send them to assessment, you send them to treatment, you can address housing, which is sometimes a barrier to treatment. You can address transportation issues. You can address, we address the whole person, medical issues. You spend less money treating the individual. And at the end of, if you're successful, because not everyone's successful, let's be honest, but at the end of the journey, you have someone where there's increased employment rates. You have someone who is able to have stable housing. You have their mental and physical health addressed, and you have enhanced interpersonal relationships. So not only have you treated and rehabbed the individual, by extension, their family and the community overall. So the cost savings and the efficiency, the opportunity that lends, $38,000 as opposed to $7,000. The cost benefit analysis outside of the collateral benefits with the housing and the increased improvement and the increased interpersonal and mental and physical health, you save money.
And one last question about drug court, and that is, tell me, with those recidivism rates being so low, tell me what is happening to the drug court graduates. Obviously, they're not coming back. So what are they doing?
So they're staying employed. Some of them come back and they want to give their testimony and they want to give back to their community. A lot of them actually join the industry and start becoming caregivers themselves. So they are people who are givers to our community as opposed to draining social resources or county resources. Those people are successful now. There's not a cure to addiction. There's not, but they know, and they now have the coping skills to address it. They know what their stressors and their triggers are. So you don't see them coming back. They understand that I have an illness. This is how I can address it. Here are the tools. And I don't have to have this revolving door of being in and out of jail.
Professor Berman, I know that you have studied extensively everything about criminal law, but I'm curious on the alternative sentencing and specialty dockets in particular. What have you seen from academia about outcomes from specialty dockets and really any type of alternative sentencing, whether that is a specialty docket, whether that is something like a community-based corrections facility or anything like that?
Thank you for that question, and thanks to the co-panelists, everybody involved in putting this together. Like an academic, I have to answer that in a somewhat academic, nuanced way, which is there's great data for well-run specialty courts, right? There's every reason to think not just that data can be replicated across specialty courts, but the heart of this, as is true for everything the government does, you do it well, you improve the community, you can develop advancements. The judge emphasizes the point about specialization, resources focused the right way on improving the lives of individuals, helping them, avoid continued criminal justice involvement. But if you don't run it well, and one of the things that in the academic community there's been concern about, and again, a poorly run alternative sentencing program can create that, is what's often called net widening, which means more people are brought into the system because we've now created this alternative. Oh, good, look, this will be good for people who have substance abuse issues. Okay, now we're out there looking for people to feed into that system, and what can be really hard to monitor, and this even gets to, maybe we'll talk about data here, both you have to track effectively who's being brought into the system, and then whether in fact, and this is so hard to study, would we have been better off, even if we maybe have improved somebody's life because we've gotten them access to services or we've helped to address whatever underlying why problem may be leading to shoplifting, leading to drug involvement. But an awful lot of people will be fine on their own, right? I mean, the reality is, and not to put anybody in this audience, on spot, but a lot of people shoplift and never get caught. And they go on to have great lives, right? A lot of people use drugs and never get in trouble for that. And they go on to have great lives. And so the challenge often is not, can we develop these courts effectively and help people who are being misserved by other parts of the system, right? Because that's really where, and I think that City Council, as City Lawyer, Klein is emphasizing this point that people, when they have criminal justice involvement, especially arrest record, especially conviction records, even if it doesn't lead to imprisonment, that itself can be criminogenic. not having access to housing, not having access to education, having barriers to employment, that will hurt life course much more than maybe even occasionally using drugs, depending on the nature of the drugs and depending on that person's environment. And so the challenge really is not just to make sure these programs are well run, but then following up with effective data to figure out not just can we keep recidivism rates down and is that good, but are we really reducing recidivism, or are we bringing people in who wouldn't have recidivated anyway, and we kind of feel good about that? And this is where I think the challenge really lies. It makes perfect sense for programs to want to bring people in, provide the services that drug courts or other kind of alternative courts can create, but we really got to make sure those are the people most in need of those services. Again, because the resources are limited. We've only got one full-time person doing this, and if you're having a lot of people who would, again, they benefit from access to the court, but would probably do okay relative to some other harder cases that maybe can't even get access to those alternatives because we just don't have them servicing individuals effectively. That's where the balance lies, and that's why this work has to continue, right? And why I need to be so much investment, obviously, from the incredible people doing the work and developing the programs, but it's where, the work of academics and other people studying to help them identify where the resources need to be located to make sure we're doing the most good with what's always going to be limited resources and always going to be a kind of a conversation about, do we have a drug court or do we have a veteran court? Well, let's have both, but let's make sure it's being done the right kind of way.
Judge Sanders.
And so I agree with you wholeheartedly, and that's why we have the multi-track approach. So there are people who just need education. They just need to understand why drugs are bad, right? Because there are people functionally who can use drugs and not have a problem. We have those people in our court system, unfortunately, because there are prosecutors who file the charges and don't want to dismiss, right? So what do? Do you let them get a felony or do you give them an opportunity? So I think you're absolutely right. But if you have a multi-track approach where you have low risk, low need, education only, moderate, high risk, high need, you can still focus your resources in the right direction. But you definitely have to track your data and you definitely have to have an assessment because not everybody needs one size fits all treatment. So I agree with you.
And I'll piggyback off that a little bit to make the point that one of the reasons I'm always a big fan of specialty courts and diversion programs and other innovations like that is typically that comes with a commitment to study and follow and build the data, right? Who's out there asking the average common pleas court judge, well, you gave 3 years instead of 2 years. Let's track whether that extra year, which again is $30,000+ to the Ohio taxpayer, what did that get us with that extra year in prison? Not clear. And that's what, often gets lost and I think is particularly unfair. We track and study and analyze the specialty courts so much, that's a benefit in and of itself. And yet we do that against the backdrop of, well, we assume the sort of normal way of doing things, yeah, that makes sense. And it often doesn't a lot. And that's where, again, encouraging the innovation and being not only committed to doing the work and putting the resources behind it, but then not asking, well, gee, is it a 0% recidivism rate? If it's more than 0%, we ought not be doing this. Well, it's not 0% for our normal ways of doing things. And so it's critical, again, not just to study this, but to study the innovations compared to what kind of becomes the default assumption of, well, that's the way we always did it. Oh, we have no data to really judge it, but that must be the way it's supposed to be done because we've always done it that way. And I think that is where, again, I very much put it on the academics and others who are trying to get into that, but often we don't have the data readily available even to do that kind of analysis.
And I wanted to ask City Attorney Klein and Judge Sanders a question about your diversion program and then about drug court too, is how do you make sure that the people who need to be in those programs are in those programs?
So I will discuss our process a little bit. So there's an automatic roll from the assignment commissioner, right? And the way it used to work is that you were rolled to drug court, someone looked at your charges, decided if you stayed, and then there was an incarceration choice and an outpatient choice, right? One size fits all. It didn't work. So what we do now is there's still an automatic roll, but everyone who comes through the door gets an assessment. If you don't need treatment, then guess what? You get intervention in lieu of conviction, you do your probation, you do your drops, and you go about your merry way.
And who's doing the assessment? Is it
the assessment team?
Oh, wow, you have a whole team.
I have a whole team.
So is it part of like pre-trial of your probation department?
So the pre-trial does the ORAS, right? They run the ORAS, they do a PSI, only for purposes of trying to see someone's risk need. Then we do an assessment clinically, and then we try to assess your need level. And so once we determine what you need, then you're slotted. So if someone comes in, and we often have those where they have no problems, they just got caught, they just got one off, they don't need treatment. They literally just have probation supervision. They have to do their random screens. They never see me. For those individuals who may need education, I may see them every 6 weeks. If someone has a moderate issue, so they need treatment, supervision, and to see me. So there literally are tracks. And so the key to it is making sure you have an assessment. I'm a legal expert, right? Maybe, but I definitely don't have the clinical experience and knowledge to make that assessment, right? So you have to be open and willing to trust the individuals that you invite on your team, that they're going to deliver the information that you need accurately so that you can make the right decision. And so, for those people, for those judges who run specialty courts, it's very important that you have the right staff and that you have the right credentialed people working for you. And so my director is not a criminal justice expert. He's a clinical director. And it's made all the difference in my program because he's able to talk to the providers and bridge that gap between the legalese and the medical jargon, correct, right? And so we make sure that we have team meetings and we discuss what the criteria is, and we make sure we stay up on the science, and we make sure that we're using evidence-based practices. And so you have to make that initial assessment is key, but you have to have the correct credentialed individuals, and you have to do the assessment. I could never do that as a judge.
Right.
So you have to have the right model.
And sometimes judges have a problem with this. Recognizing what we don't know.
Right. So, right. And so you have to have, sometimes part of our job is changing hearts and minds, right? You have to have people who are willing to come to the table, buy in to the training, make sure they're knowledgeable, and then commit to fidelity to the model, right? So a lot of times that's why you have such disparity across the country in how drug courts are administered. So you really have to do this work. It's a lot. You have to be committed, and you have to have the right staff, and you have to make sure that credentialed properly. Because you're right, you can actually you can increase someone's criminogenic tendencies if you overtreat them or if you label them wrong. So it's really, really important that you are doing what you need on the front end so that you don't necessarily
do something bad on the back end.
Right.
Mm-hmm. What about you, City Attorney Klein? How are you making sure that the people who need to be in your diversion program get there?
Well, so in Franklin County Municipal Court, we have a series of specialty dockets.
Yes.
And as it relates to the specialty dockets themselves, they're judge-driven, very much like your court. And so the judges will, whether the case is before him or her, on the regular docket may flag someone for their specialty court docket that they run. Defense attorneys may flag a client. And then we have an internal processing system, and we give a lot of free rein to our prosecutors that if they feel like a defendant is eligible or should be in a specialty docket, to make that request to put it before the judge for consideration. On the diversion side, which is separate from the specialty docket, when we started with the Buckeye diversion program, it was pretty clear criteria. You committed a shoplifting offense and it was somewhere between 0 and 8 previous offenses, we would consider you for that program. Our biggest barrier most of the time is the defendant and the defense counsel doesn't want to participate in the program because it's easier to eat the charge than doing the hard work necessary to visit a food pantry and hold the hand of the social worker to navigate the social system that's necessary. And that's very frustrating to me, is that here's this great program that's a proven success, but the defendant or the defense counsel is pushing their client not to participate in the program because the easier way out is the fine, or the easier way out is the community service. And so you don't get that opportunity to change someone's life.
Another question for all of you. In our very polarized society right now, you have some people in one camp that say, just lift up the prisons and throw everybody in there. Then you have another group of people that say, no one should ever go to prison, ever, for anything, And so when you all are, whether it's, in academia or at a cocktail party or what have you, what do you all tell people about that? What is your perspective?
I mean, I'll particularly emphasize anyone who has a one-size-fits-all or even a 15 sizes fits all approach hasn't had multiple children, right? Doesn't understand that, even folks who we think look very similar, and that is so fundamental. And again, I'll emphasize sort of 2 points here. One is, as it relates to public safety, right? So two people can commit the exact same crime, and interventions might need to be radically different depending on their backgrounds and what drives the crime and the way to enhance public safety going forward. And there will be some individuals, and part of the challenge is it can be very hard for lawyers, court personnel, others to identify which intervention will work well. And I'm in the camp of, there are some people who need to be in prison, in part because for some people, prison serves as that bottom, right? That like, okay, this is serious, important, impacting my life. There are other people, though, especially I think those who have had experience, whether it's jail or prison, where it's like, that's just the cost of doing business. And I'll rather do that than hang out with a social worker. And it's very hard to identify that ahead of time, but it's where they all should go to prison or nobody should go to prison, kind of approach just misunderstands just the complexity that's right there. But then it's a point, again, that sort of emphasize prison is a very expensive intervention, right? It's where we're spending a lot of money essentially to do nothing else these days than warehouse individuals, right? And
I know at one time, Professor Berman, it was more expensive to house someone in prison for a year than it was to send them to Ohio State for a year.
There is no doubt that in terms of sort of return on investment, it's awfully hard to make a very good pitch for imprisonment, especially because the more people you put there, the harder and harder it is to do any kind of rehabilitation while you're there, right? So that's one of the things, and this has been a reform at the federal level, where there's been a greater investment in prison programming and to help people get the skills they need to re-enter into society effectively. But the more people you have in prison, the harder it is to run those programs. The more overtaxed there are, the more money you've got to spend to make those programs potentially effective. And so there are tipping points and balances to achieve here that, I sometimes cheekily say, well, that means I'll always have a job trying to figure this stuff out, right? But it's also where I think it's not just something that's important to carry to prison. It's something that carries to diversion and specialty courts and everything that's going on, how pleas get put together. Anybody who says, well, this is the one way to do it, and this will solve our crime problem, or this will be justice, is just not understanding, how complex human nature is, human behavior is, and how righteously complex we want our legal system to be to attend to all these competing values. Because, of course, the last part of this that I want to sort of emphasize is public safety, critically important, return on investment for public safety, critically important, but then everybody thinks there's a certain notion of justice as well. And that justice not only includes, what's the right sentence for this individual in light of the harm they caused, but justice across cases, right? Having an equal system that tries not only to treat like cases alike, but different cases differently. And that just demands an extraordinary amount of time and attention. Again, maybe I'm just justifying why we need law professors to help us sort all this out. But I think it's to me, that's where I sometimes almost get tired of being like, well, it depends, right? It depends on the nature of the offense. It depends on all these other actors in the system. And that's where I kind of maybe bore people at the cocktail parties when I say, like, all right, you got 3 or 4 hours and we can sort of talk through, let's talk about diversion first. Let's talk about bond, all the things we've been talking about. Let's talk about all the disparity. Oh, and on top of all that, do you realize there's a local system that the city runs, and then there's a state system that the state runs, but actually it's county elected officials that kind of run that, and they've got to worry about politics. Oh, and then there's this thing called the federal system, which kind of was layered on top of this, that influences everything. And again, it's not meant to kind of highlight just how complicated things are, but that system evolves in part because we understand there are a lot of nuances to the way in which we ought to try to advance justice and public safety. And that's why, this not only justifies so much time and attention, but really requires, in all those political debates, people not to be so, well, I think I've got it figured out, and the other side, they don't care about public safety, or they're only worried about this or that, or they're, just too tough or too soft. Just any shorthand kind of, just terminology or rhetoric, by definition, I think, is going to undervalue what we're trying to achieve in a sensible justice system. But that's a hard message. I get to be a tenured professor sitting in my ivory tower. I don't have to run for office. And, already that answer was so long, it doesn't fit on a bumper sticker.
It's a big car.
Yeah.
Well, and City Attorney Klein, I'm interested in your answer too, and because I would assume that because you have a prosecutorial part of your job, that people assume that you're in the camp of lift up the jail and just put them all in there. And knowing you personally, I know that you're not.
Right. I think that the criminal justice system is not immune to the fringes of policy and politics that every other issue facing our country is now dealing with. Either lock everybody up, everybody go free. Defund the police can do no wrong. Universal health care and Medicare for all, or only private insurance markets run it. The reality is, the answer is in between, and that's if you turn off your social media algorithms, you will find that's where a vast majority of people understand that as it relates to the criminal justice system specifically, there are bad people that deserve to go to prison for a very long time.
Yes.
And at the same time, there are people that need help who make bad decisions, who find themselves interacting with the criminal justice system. Both those exist at the same time. And it's not a lock them up mentality, but it's also not let them all free mentality. And I was actually thinking about this in response to your question to the judge regarding the criticism amongst the bench of whether specialty dockets are good. For many decades, we had, in my opinion, this kind of hammer approach to criminal justice where it was lock everybody up. And that really led to the term mass incarceration, which is why we incarcerate so many people in the United States, especially compared to the civilized world, right?
Mm-hmm. And then a lot of times we said, oops, this is really expensive.
And it's very expensive. The reality is that we do have to incarcerate really heinous people that commit very serious crimes and threaten public safety.
And whether anyone wants to acknowledge that, they do exist.
They do exist. But fortunately for society, they are a small number of the people interacting with the criminal justice system. So at the same time, we have this real opportunity for those that do have drug addiction, that do make mistakes, to use the system because they have committed a crime and interact with the system, for them to change their lives for the better. Those are the vast majority of people that are interacting with the criminal justice system. It's not the heinous rapists, murderers, robbers that cause so much physical and violent damage in the aftermath, threaten public safety, and there's real victims who need help because of the things that they've done. The vast majority of people that are coming through the criminal justice system, especially municipal court and misdemeanor crimes, are folks who just need help and be pointed in the right direction. And that's the way we've tried to balance the criminal justice system under my tenure as city attorney, is understanding we do everything from theft and traffic all the way up to domestic violence. And
right.
Obviously very serious domestic violence.
And OVIs.
Mm-hmm. And we're not afraid to ask for max sentences on domestic violence and violent individuals that are hurting the public, or repeat OVI offenders that are threatening people driving down the road. And then on the flip side, we're also not afraid to say, let's put someone in a diversion program that changed their lives. They both exist at the same time. And that's the real world. And frankly, I think how we have to approach the criminal justice system.
It's interesting the way that you said that, City Attorney Klein, because then it also makes me think of, the people like you and judges, really sometimes what they're figuring out is how they're going to allocate their resources. There's only so many spots in the diversion program. There's also only so many spots in the jail, so many spots in the community-based corrections facility. And so taking in all that information helps you decide where you're going to use your resources that you have available to you. Judge Sanders, what do you think?
So I use 4 words: compassion, justice, accountability, and problem solving. My job as a judge is not to just be reactionary. I'm supposed to be proactive, and I'm supposed to solve problems. Sometimes that means holding someone accountable.
Yeah.
Some people,
trouble is our business.
Somebody got to be locked up sometimes.
Mm-hmm.
But sometimes that means being compassionate and trying to get the just result. And that means solving a problem. And so those are the 4 words I use when I'm at somebody's cocktail dinner. And they're like, how can you do what you do? And so I smile because I love what I do. And then I give them statistics, and I try to, make sure that their mind is open. If you have an open mind and you can change, I always say, half the battle is changing hearts and minds, then we can have that conversation. But those are my 4 words: compassion, justice, accountability, and problem solving.
Justice Donnelly, what do you think? Especially you are someone who has to campaign statewide. So I know you really hear from both camps.
I do, and I think what you've been hearing from my co-panelists is we need to move into an era of being smart on crime rather than tough on crime. One of the benefits of my position, I've traveled through this diverse state and spoken to groups on the conservative end of the spectrum and progressives. And one thing they have in common in this polarized time is from the courts, they're looking for fairness. And I think what you're hearing today is the most important issue of our time is the need for Ohio to move towards a data-driven, comprehensive criminal justice system, especially
that's why I asked you last, because I knew it would segue into that.
Yeah, well, I tend to try to segue into this as much as possible. Today, I brought with me a report from 2002, and it was put out when the late Chief Justice Moyer commissioned the Racial Fairness Implementation Task Force. So they were talking about the same issues that this program is talking about. 2002, 3 years before I began my 14 year on the trial bench. And I would urge the viewers to look, to Google this report, because amazingly, they are calling for the collection of data. How do you, in a system where you want the outcomes to be based upon the rule of law, which requires fairness, consistency, proportionality to the crime. How do you do that if you don't have the data to keep yourself as a judge consistent and know what the other judges are doing? How do you treat similarly situated, likes alike, if you don't have the data? Ohio does not have a centralized data. And as a result of that lack of data, and the scheme that we have, and it's not the judge's fault, they are powerless to deal with this issue. In Ohio, you can take one set of facts, usher them into one court judge, have a sentencing hearing, and end up with an outcome of probation. You can take that same set of facts, walk 15 feet across a hall, and have the sentencing hearing in front of another judge, and sometimes wind up with decades in prison. That's the kind of disparity that the system as it's presently designed is designed to produce.
And Justice Donnelly, would you also say that, you could get that with the same set of facts, but also with same criminal history?
Sure.
Right?
Yeah. And, you see this kind of disparity, but we don't have the data to look at the trends. One of the most important news stories appeared on Cleveland.com not too long ago, and it dealt with a white defendant in one courtroom who had been convicted of stealing $250,000 from a school system. And then there was a black defendant who was sentenced the next day for stealing much less, $42,000 from another school system. So there was an astute reporter. This wasn't a big, deep data dive. It's just a reporter that happened to be in the right place at the right time and saw two sentencing from what appeared to be like crimes, two very different outcomes. The white defendant received probation and the black defendant received an 18-month prison sentence. Okay, so that went on Cleveland.com's lead story, which usually has about shelf life of about 2 or 3 hours. That stayed on there for literally days upon days because it was being tweeted and retweeted throughout the world. And people were like, what's up with Ohio? How does this happen? And it's not the judge's fault. They don't know how other judges are treating similarly situated defendants.
Right, that's your whole point, isn't it?
They don't have the data. They don't. So it is crucial that we don't let what happened to this report, it went into a file somewhere and gathered dust. We haven't moved the needle one iota in 20 years since they called for this. And now we need to develop the political will to have this data and move Ohio's criminal justice system into this century.
So what do you say, Justice Donnelly, to the people who say, we don't need this data, I'm going to sentence how I want to sentence? You know, I ran for judge, I'm the judge, the decision's up to me. I don't need to know what other people are doing.
Well, there are some judges out there who are resistant, and what I try to convince them is, you know, this isn't an option. The genie's out of the bottle. Data is coming, whether you like it or not. And you're going to have academics, you're going to have journalists scrutinizing your sentencing decisions under a microscope where so powerful you've never seen it before. And they're going to be drawing conclusions about your sentencing and why you're doing that. And if you want to be able to defend yourself from possibly unfair conclusions or inaccurate conclusions that are out of context, it behooves you to have the data yourself so you can put those decisions in context. You know, it's all right in our system to treat people differently if you can articulate a valid reason to do so. And you can do that. You can see that with mental health courts, with drug courts, with veterans courts. Why are we treating these people differently? But if you're treating people differently and the data shows it and you can't articulate the reason why, then there's a problem. Because our law very clearly states that similarly situated defendants are to receive similar sentence outcomes regardless of the color of their skin or their place in society, socioeconomic place.
I'm sorry, may I add something? And this is, I think, is a very small sliver of light, I think, as it relates to the changes that still need to happen, whether it's the data-driven changes, Justice, or the policy changes at the legislature here in Ohio or at the federal level in Congress, is that if there is, in this really turbulent political time, an area where there seems to be more compromise than not between Republicans and Democrats, it's criminal justice. Now, the motivations may be different.
Yeah, I was going to say, for different reasons, perhaps.
But from a policy standpoint, that's fine with me. It doesn't matter what you. It's like, but the end goal is the same, right? It's like some may come because, hey, we're spending too much money on incarceration. Some may come because the system's unfair and needs to be fixed. But they all agree at the end that it needs to be changed, and that's where the commonality comes, which is why the Koch brothers and George Soros team up. It's why Americans for Families Prosperity and the ACLU. I mean, these are. If you don't know anything about these people or groups, they are the fringe, like
and
liberal, conservative, polar opposites, but they find commonality on criminal justice issues, which is why I think we've seen across the country and even some of the reddest states, some holistic and important major changes to criminal justice. So like change continues to happen in this space, even though our politics is broken in our country, because people have, with different motivations, a reason to fix the system.
And Judge Sanders, speaking of data, I noticed that when you were giving your answers, you were using data. You know, you were talking about recidivism rates, multiple year recidivism rates, and costs, which I include as data for me anyway. But so tell us, how has data come into play with the success of your drug court?
So, unfortunately, there was not a lot of data available when I took the bench, but we've partnered with the University of Cincinnati, and so they're going to analyze our outcomes and our measures, and they're going to report them to us. We also have purchased a data collection program so that we can, one, report our statistics to the Ohio Supreme Court, but we can track our outcomes and then we can adjust our program when we figure out what's successful. So for the first time ever, we're able to track recidivism rates. We're able to track, eligibility criteria and who's actually allowed in our program, because that was a big problem too, right? You have to adjust your eligibility criteria to make sure that everybody has an opportunity to participate in a specialty docket, right? And so we've instituted data because it just wasn't there, and it's bearing its fruit. It's going to take a while because for the 20 years plus that the court has existed, there's never been any data collection, but we've partnered with the university and we've bought some software ourselves, a program ourselves, so that in 2 to 3 to 4 years, we can look back and say, oh, this is how we were successful, or maybe not, or we need to have better outcomes. We can justify what we're saying.
I was going to say, Professor Berman, I know that for you have said it all starts with data and having data. So give us your view from the ivory tower.
Sure, I'm happy to give the view from the ivory tower. We can see data. I was going to really sort of drill into it in this way, data really is a piece of infrastructure. And it's so critical, but it has the same challenges of investing in infrastructure, as the judge was suggesting. Like, you don't get to cut a check for data and then you have the data the next day, right? You got to build not just a commitment and resources to collecting the data, but collecting it over time, right? And especially recidivism is the one that's sort of fascinating and fascinating in a really challenging way. If I'm just going to monitor the first 6 months after somebody's released from prison or in a diversion program or whatever else, I'm going to have pretty good looking data, because people often, there's certain groups that recidivate quickly, but a lot of folks, it's a year, 2 years, 5 years. The Justice Department has a 9-year recidivism study. Now, at the same time, there's a flip of that, which is if you follow enough people for 9 years, they're going to get their hand caught in the cookie jar one way or another, right? And so there's a balance between both investing the time and the resources into collecting the data and making sure it's good data, right? And that's something that takes a lot of time, takes a lot of energy. I feel confident always, whether it's for the state of Ohio, at the city level, at the federal level as well, that's data that's going to give a return on investment better, dollar for dollar, than that one more year in prison for that person who maybe they need to be in prison, but 7 years versus 6 years is not going to change the delta on their lives at all. But that money devoted towards maybe even studying that one person in a sustained way is going to give us insights that we can carry over over time. But to me, it's sort of a no-brainer to encourage investments in data, and I think we're seeing more and more of that as we're getting the bipartisan consensus moving away from just lock them up or kind of short-term thinking. But I also think it's important to highlight that that's just the starting point, both because it's hard to collect this data over time, and there's going to be debates over what the data tells us, because the data will say a bunch of different things depending on kind of how we slice it and what we care about. If we're going to, this is my favorite one to sort of focus on that's just so hard. If you are going to slice the data only looking at racial issues, that's going to give you a different lens on it than if you did it on socioeconomic issues. And those things are going to overlap in all sorts of really, really important ways. But at the end of the day, it's probably, tell me somebody's socioeconomic status, I'll make much better predictions about what their recidivism life course is going to be than telling me anything about their race, or even gender's a little complicated in that way too. And so, again, it's not just collecting the data, but understanding it's a lot of data, and we need a lot of really smart people. Again, I don't want to make this the pitch for more academics, but it's going to actually demands also people who are doing the work in the courts, in the system, to help us understand what that data really tells us. And I think pleas are the kind of best example here, where if you look at all the sentencing data and you take away whether somebody pled guilty or went to trial and try to line it up without knowing how the case worked its way through the system, it's going to so distort your understanding. And of course, every practitioner knows that. Well, of course, there's a plea discount, and that has all sorts of echoes to it. But that's where, again, us academics, we try hard. Most of us, have had some experience in the system at various points to unpack the data effectively. But we need help, not just understanding the data that we are collecting, but also knowing what data we should be looking at that may or may not be, fundamental. And this is where, again, Justice Donnelly and all the folks working at the Ohio Criminal Sentencing Commission, they're putting together a great team with lots of perspectives to build this database the right way. And I'm very confident we've moved at least an iota, at least fairly recently, thanks to your work, Justice Donnelly. But it's not going to be something that, overnight, well, there's a super highway of data and now we have everything. And that willingness to make that long-term commitment and to have people understand how important that is, I think is so central. And it's interesting because I've only come to fully understand it in a way that leads to how I'm teaching my students. So I'm having my students in my classes actually ask data questions. What data do you think we need more of in order to better understand drug policy reform or better understand criminal sentencing? Because I think it's something, I didn't learn that in law school, right? In fact, this is the kind of running joke for lawyers sometimes. Yeah, I went to law school because I wasn't really good at math. And
Exactly.
I didn't like the math stuff, right?
Yes, it can be a haven for people who don't know what they want to do.
And I think it's important to understand those are part of our barriers, right? I think that's a little bit maybe of some of the judicial pushback, like you were saying with your question, is like, hey, I'm the judge, and who cares about the data? Justice doesn't involve data. It involves this case in front of me. It's like, yeah, but there's more to that. So I think that's recognizing our own challenges to not only collecting the data, but understanding it and working with it and being excited to work with it is such an important part of moving forward here effectively.
And Professor Berman and Justice Donnelly, one thing that I've noticed, particularly when you start talking about the 3 C's, the areas overlap several counties. And so you can have a situation, we'll take Columbus area, for example, where the suburb Pickerington, some of it is in Franklin County and some of it's in Fairfield County. And so you can commit a crime on one side of the street, that's Franklin County, with all of its resources, and have one penalty and have a completely different penalty if you're on the other side of the street in Fairfield County. And so how would having data help with that disparity and any others?
Well, data is going to inform our policymakers where to allocate resources. I've spoken with judges in rural areas that say, we would love to have a drug court, or but we don't have those kind of treatment options available. So we're sending people to prison simply because we have no other alternative. And so to end that disparity, our lawmakers are going to be able to analyze that and see where to allocate resources where they're needed.
They would know then, for example, that said rural area needs something like a community-based corrections facility.
Correct.
Mm-hmm.
And I also think this extends not just to how we allocate resources within the state, but our ability then to communicate effectively to the federal government, which last I checked keeps printing money. And so, there are all sorts of different tools. It's part of the bipartisan coalition that's there, where in fact, the federal government knows most of the work is being done at the state level. And there are opportunities to request federal resources to help run our systems better. But if you don't have data, especially if we don't have data and the other state across the border does, and they say, look, here's where we know for sure X number of dollars invested in record clearing or defense services or whatever else, drug courts, we know that's going to reduce crime in this area. You're going to get funding that way much more effectively than if all you say is, well, we kind of hear from a few people that we could use some resources here, right?
Yeah,
and so
yeah.
that's where it builds off itself and can be a basis for not just, again, doing better day to day, but understanding the system in the kind of ways so that we can, as you were talking earlier, it's always going to be a resource challenge. Where do we allocate our time and our energy most effectively? And I think it's something that data can help answer.
All right. To our panelists, on behalf of the Ohio State Bar Foundation, thank you so much for participating. And for those of you watching, thank you very much for your participation.